Hello, everybody.
Okay, court next calls the people of the city of Cadillac versus Thomas Wayne Spencer, case number 25659OM. Appearances, please.
I'm Jeff Harrison. I'm going to be having Mr. Spencer.
And we're here for a pre-trial today.
Indeed.
What are we doing?
My understanding, the defendant will plead guilty as charged.
That comports with my understanding as well.
Who's the jail?
Hold on, I think we've lost the jail. Okay, we are back on the case of City of Cadillac versus Thomas Wayne Spencer, case number 25659OM. Mr. Spencer, I'm not sure at what point we lost you, but counsel made their appearances and it indicated that this was going to be a plea as charged. Is that your understanding?
Yes, Your Honor.
I have a signed advice of rights form in my file, talked about your rights to an attorney and your rights to a trial. Did you read and sign that form?
Yes, I did, Your Honor.
Do you have any questions for me about those rights?
No, I don't, Your Honor.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind?
Yes, I do, Your Honor.
Will you please raise your right hand, the best you can? Do you solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your
Go ahead and put your hand down. Has anybody promised you anything in order to get you to plea?
Honor. No, Your Honor.
Has anybody threatened you in any way in order to get you to plea?
No, Your Honor.
And is it your own free choice to enter a plea today?
Yes, it is, Your Honor.
Then to the charge in count number 1 that on March 4th, 2025, here in the city of Cadillac in Wexford County, Michigan, you were a disorderly person. How do you plead?
Guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that you did that makes you a disorderly person. So what happened back on March 4th?
I was at the hospital and trying to get a heart loop monitor put in because I have AFib and my heart stops and I pass out, bust my face. With no warning, I don't know I'm gonna go out because my heart's stopping is how U of M figured it out. It's been 2 years. They've been trying to find out why I was passing out. And police busted me in the face with a billy club and I got 34 stitches a year ago. And then while they stitched me up, they sent me to U of M and they figured out it was my heart. They said, your heart's stopping.
Okay,
And if you don't,
okay, but what makes you a disorderly person here in Cadillac back on March 4th?
The doctor that's at the hospital put me outside. He wouldn't admit me and he put me out a 17 below zero wind chill with just a blanket and a cup of coffee. And he was arguing the fact that I wasn't supposed to get this heart loop put in. So I started yelling at him and that was my disturbing the peace.
And when you were yelling at him, was that inside or outside of the hospital?
Inside.
And would you agree that that would cause a disturbance to others inside the hospital?
Yes, I do, Your Honor.
Do you counsel believe that the defendant has given a factual basis and that the court's been compliant with court rules?
I do.
I do as well.
As does the court. Mr. Spencer, I find you guilty of disorderly person, penalty of the 90 days in jail and or a fine of not more than $500. Mr. Harrison, any allocution?
Well, Your Honor, he and I discussed it to some length. We believe that the events of the evening clearly show he was a person having some type of mental health issue or event anyway. Does not excuse his conduct. He is aware of that. He understands that he caused a disturbance in the hospital and broke the law. He has been incarcerated for a great, well,
I show 22 days.
22 days. Okay, I thought it was more for some reason. I apologize, I got sidetracked. He's been incarcerated for 22 days. He is aware of the fact that he needs to keep addressing his mental health, and he's going to do that. He's got stuff set up to take care of that when he gets out of jail. This is one of those situations where he believes if whatever cycle he was on that night hadn't been interrupted by, unfortunately, this event, it wouldn't have ended well. So in a way, this was a good thing that happened because it forced him to slow down and take advantage of services and resources that are available in the community. He's 63 years old. He's aware that his primary obligation to himself as well as to the community is to take care of his mental health, and he's got a plan to do that. I don't see the point in supervising him, nor do I see the point in any further incarceration pursuant to this matter. Thank you.
So Harrison, you mentioned something along the cycle that he was on. What do you mean by that?
I just mean whatever had happened that night that caused him to have some distress in his mental health, to behave what he termed to be, and he used the word irrationally, in response to a disagreement with the doctor. He knows now that you don't go to the emergency room and demand this kind of service, that there's sort of a chain of command that has to be followed. He, for some reason that evening, was unable to do that. So he's glad that that thought process got interrupted by this event. I mean, he's not happy about being in jail, being, taken off his meds and all that kind of stuff, but this was a way that operated to bring about a positive result, at least for the future.
Okay. Ms. Carey?
Thank you. He was causing quite a disturbance at the hospital. He was aggressive towards staff. He locked himself in the bathroom. He was lucky he wasn't charged with R&L. He was continued to be aggressive with police. He possessed them. He had in his possession toilet paper that had been burnt and soaked in alcohol, whatever alcohol he had in the hospital.
Well, I've been close
He has
over
a
50.
history, a lengthy history, and it looks like he has a bench warrant out of Kalamazoo for an incident in January. The bench warrant looks like it was issued on February 13th for retail fraud third for failing to appear in Kalamazoo. So I would ask the court to take that into consideration. Thank you.
All right. Well, there'll be a $75 crime victims' rights fee, a $50 state minimum fee, a fine of $150, court costs of $150. Attorney fee, Mr. Harrison?
My involvement just today, he doesn't have any money.
Is that a waiver of attorney fee?
Yeah.
Mr. Spencer, is there anything you'd like me to know before sentencing?
No, Your Honor.
Well, Mr. Harrison has said that you've learned certain things from this episode. Is that true?
Yes, Your Honor, I have.
Have you been getting the necessary help that you need while you've been in jail these past 22 days?
Yes, Your Honor. I've been on, for 30 years, I've been getting mental health. That's why he sent me out 22 days, because he said that I was a danger to the community, and they turned down my PR bond 22 days ago. I was honest with him. I said I got molested as a little boy, and I've been on my meds for 30 years. And he said, oh, you're a danger to community. So he sent me out 22 days to court.
Well, I was the judge who did that arraignment, and I remember your arraignment, and there, you seem to be doing better today than you were back then.
Oh, absolutely.
What are your plans if you're released from jail? What do you plan?
I'm going to rehab in Florida. The police in Kalamazoo, this warrant, the state police had me in the car the other day, the day that I came in here, the same day. And the Kalamazoo said, get them handcuffs off him and let him out of the car. The reason I have a warrant is because I was up here. I can't be in here in Kalamazoo at the same time. So I'm going back to Kalamazoo. The police are sending me back down there on Indian trails. I'm going to take care of that warrant, and then they're sending me to Florida to a rehab in Gainesville, Florida.
In Gainesville?
Yeah.
Okay. Is there anything else you'd like me to know?
No, that's it, Your Honor.
Well, there'll be a $75 crime victims' rights fee, a $50 state minimum fee, a fine of $150, court costs of $150. Attorney fee, Mr. Harrison?
My involvement just from today, he doesn't have any money.
Is that a waiver of attorney fee?
Yeah,
I'm not going to order probation, Mr. Spencer. I'm going to trust that you're going to continue to get the help that you need, okay?
Yes, I will, Your Honor.
I'll order 22 days jail with 22 days credit. That means you get released today, once your paperwork's been processed. You understand that?
Yes, sir. I can pay this fine as soon as I cash a check. The state police has a $4,000 arrearage for Social Security that got stolen from me, and it should be at the state
Okay.
police post. If not, it'll be here in a week if they reissue another check, so I'll pay this off within a week.
Okay, well, I show that's $425. So just as soon as you're able to make a payment on that, if you have any balance, it's more than 56 days late, there's a 20% penalty. Do you understand that?
Pay it in full, Your Honor, this
Okay,
week. As soon as I get the check.
all
it'll be
right.
paid in.
Counsel, anything else?
nothing for you.
All right. Thank you, Mr. Spencer. Good luck to you.
Thank you. Have a great day.
You too.
Before making,
Yes, Your Honor. Defendant enters a plea to count 2. We will dismiss the balance of the charges. We have sentencing guidelines at 0 to 11 months. We will cap an incarceration in the county jail at 90 days.
Mr. Prysock, is that your understanding of the offer?
It is, Judge. If I could just have 1 second with Mr. Massey.
I'd like to say something, Judge.
You need to talk to me. Okay. You're going to try.
Yes, that's my only option. It's not an option, I'm not good to.
Okay. All right. Judge, at this point in time, Mr. Massey rejects the offer.
Okay. All right.
And I think he wants to address the court for some reason. It's fine with me.
All right, Mr. Maslick, is there something that you think the court should know?
Yes, I'd like my attorney to hand you this.
What is it? Mr. Maslick, what is it?
It's a motion to represent myself.
Okay. All right,
It
so,
looks like, you can take a look at it, Judge. It looks like motion to remove me from the case. And then it's a motion to dismiss. And looks like a petition for a same-day sentencing, so.
okay, all right, so Mr. Maslick, why do you no longer want the services of Mr. Prysock?
Well, he didn't inform me that my case number was changed on my file. And
Oh, yeah.
I just got,
So, the case numbers, when they start out in district court, they get a certain district court number, and then when they come to the circuit court, they get a circuit court number. That happens in every case. It's on the paper.
okay, well, also I find this whole ordeal a conflict of interest. And that's never been addressed, and I've addressed it every time.
What's the conflict of interest?
So my cousins are Paul and Matthew Jones.
Okay,
So Mr. Prysock here represented them.
okay.
So I'd like to represent myself so I can file my own motions there.
Well, the fact that Mr. Prysock represented one of your cousins 10 years ago, 9 years ago, doesn't have any impact on this case.
Okay, and then there was also some miscellaneous actions done in my report, and there's 70 incidents on my miscellaneous actions by clerk, refer to administrative actions. Like
All right,
my
that's fine. That doesn't sound like anything that has to do with Mr.
The lead
Prysock.
witness.
No, Stop.
Can I say one more? thing?
No, not. So that stuff doesn't have anything to do with Mr. Price. But the person does have the constitutional right to represent themselves. Okay? Court has to find that you have made a knowing and voluntary waiver of your right to counsel. So you do understand that you have the right to hire somebody if you want. You understand that?
Yes, sir.
You understand that you have the right to have the court appoint an attorney to represent you if you could not afford an attorney. And that's why you've got Mr. Price on. You understand that?
Yes, sir.
You understand that there's risks associated with representing yourself.
Yes, sir.
Like you may not know the rules of criminal procedure, you may not know the rules of evidence, you may not know how to effectively cross-examine witnesses, you may not know the process to have the court issue subpoenas for anybody to testify on their own behalf, you may not know how to secure any expert witnesses that you may need. Looks like there's a charge of possession of amphetamine. You may not have the technical knowledge to cross-examine the question any state laboratory person that they would call in to know about the procedures that they have to follow to certify their equipment. I mean, there's a lot to representing yourself that you may not know. Do you understand the risks there?
Yes, sir.
Okay. And bearing those risks in mind, do you still want to be your own attorney?
Yes, sir.
Okay. You've heard the saying that a person who represents themselves as a fool for a client. You've heard that before, right?
Yes, Your Honor.
Okay. There's been several people that have represented themselves in circuit court. None of them have ever been found not guilty after a trial.
Yes, Your Honor.
You understand that?
Yes, Your Honor.
Okay. So bearing all those things in mind, you want to represent yourself.
Yes, Your Honor.
Okay. All right, so the court does find that you made a knowing and voluntary waiver of the right to be represented by an attorney. We'll set this case for trial. You've been in jail most recently since the first part of February, is that right?
Yes, sir.
Okay. Set you for trial August 19, 20, 21, and 22.
And I have some motions for you, Your Honor.
Well, hang on. That's one of those things where if you had an attorney, they would know the process to do that. So to file a motion, you have to file it with the court clerk. You have to get a copy to the prosecutor, and you have to get a hearing date. So it's not something that you can just throw it on the prosecutor's desk or my desk and say, let's do that today. It's not the way it works. They have the time to prepare and research the law, get any witnesses that they may need to help them in the case. So if you want to file that, you can submit it just like any other attorney or self-represented person could do to the circuit court. You need to have a copy for the prosecutor, and then we'll notice it up for a hearing. Okay? It's complicated. You'd be much better off with an attorney, but it is your right to not. All right, that's all for today.
Just for the record, I have given Mr. Nassler copy of the police report, the indictment, and his preliminary transcript. I will go through my file, make sure that, I think there's still some things in there I was going to get to him.
Thanks again for coming out. Be safe, be well, sleep sweet, and much love.